Yeah, thank you very much for inviting me and Dr. Rena Yulia to present in the first international conference on the social environment diversity 2024 organized by University Semarang 5 November 2024 with the topic New Paradigm of Diversity and Sustainability in Social and Community. This is for the disclaimer. This is the research organized by me as the chair of the research, and Dr. Rena Yulia from the Universitas Sultan Ageng Tirtayasa Faculty of Law. The title of our research is Access to Justice for Child Victims, examining the juvenile justice system. Like in Indonesia, we call that Sistem Peradilan Pidana Anak. But we focus for the how to access justice for the victim. Why we conduct this research? Of course, we have some backgrounds. The first is the phenomena of the cases involving children as perpetrators. We call that children conflict with law. And in the children conflict with law, not only they are perpetrators, but also victims. And the number of the perpetrators and victims are increasingly common. The second, why we conduct this research, the resolution of the cases 11 of 2012 regulated in the number concerning the juvenile criminal justice system. Of course, in the certain cases, juvenile cases can be resolved through diversion and with the restorative justice approach. The diversion process can be conducted at any stage of justice system, from the police, prosecutor, and the last level is judges. Through diversion, children conflict can be freed from legal bondage, and child victim can get recovery, rehabilitation, and of course join with the community. And also we can be in the form of compensation in accordance with the agreement. Diversion arrangement in the criminal justice system law does involve child victim in the process. This is the question. Are the child victim involved in the diversion process or not? Yeah, this is our question of research. Yeah, the first, when the diversion process, child as victim involved in the process, and the second, whether the child victim participated in the process of the diversion. So this is the question, and then we will carry out the victim also as a child, as many cases that have occurred recently. Therefore, the research is interested in examining access to justice for the child victim, dissecting the juvenile justice system. And the objective of our research is the first. There are two objectives. The first, analyze whether diversion is the best interest of the child. This is as a principle of the criminal justice system, the global system. And the second, dissect how access to justice for child victims in the juvenile criminal justice system in Indonesia. How to access the justice for the child victim, because the children conflict law, they are victim, perpetrator, and witness. So we focus for the victim. The method, of course, this is a normative research. we used normative legal research with statutory approach, and also for enrich the data, we also conduct some interview with the law enforcers, namely diversion investigators at the Serang city sector and resort police, and also BAPAS. BAPAS is institution for correction, yeah, under Ministry of Law now, yeah, before under the Minister of Justice and Human Rights. And then this is some result of our research. I think you are very interesting, I think, with our result, yeah. Diversion and the best interest of the child. This is the topic of our result. Diversion is the resolution of the children cases from the criminal process to a process out criminal justice. It refers to children who are conflict with law, not only as a perpetrator but also as a victim. The criminal justice system law fully regulates the diversion process. Next, among other things, how the involvement of the child victim in the diversion process, whether the child victim have the right to obtain assistance, the right to obtain compensation, including the right to refuse diversion. The goal of diversion is to achieve peace between the victim and the child as offender. Other goals are entirely for the child perpetrators. There is no goal to restore the victim of the criminal offenses committed by the child. For example, this is this paragraph or this result, yeah, regulate in the Article 6 of the Criminal Justice System Law. The diversion process must consider the interest of the victim, Article 8 of the Criminal Justice System Law. In fact, the victim has a role to determine which agreement is desired. In some cases, there are requests for compensation that are beyond reasonable limit, until finally no agreement is reached and the diversion process is stopped. The second concern on our result, based on the interview with the police investigator and community supervisors in the diversion process where the perpetrator and the victim are children, it's known that both the perpetrator and the victim children attend the diversion process accompanied by the parent guardians. Ex-child victim is given the same opportunity to express their wishes. If an agreement is not reached, then the judicial process will be continued, yeah, in the prosecutor office level or the judge's process level. In the diversion process, child victims also have role in determining what kind of justice they want to achieve, but in practice, the dominance of parent is more visible and children are more silent. And of course, the children cannot use the right to voice because dominate in the process of justice are in the parent level, parent hand, I mean. For the second question, this is our result. Of course, this is the last question. Access to justice for victims in the juvenile criminal justice. The diversion process which involves the child offender and the child victim in the reaching and agreement is an example of case resolution that provides access to justice for the victim. In the case, the child victim to express her needs and desire in involving the case. In the practice diversion, based on the interview with the investigator and community supervisors, child victims are always involved in the diversion deliberation process. Child victims are accompanied by their parents or their guardians. It's even possible to be accompanied by the third parties concerning with the children, as like P2TP2A or the Child Protection Commission under the local government. This means that not only the perpetrator child is accompanied by by a companion, but also the victim's children. If the result of diversion agreement are not implemented, then the diversion fail, of course, and the case will process to the court, and this under the supervision of investigator and community supervisors. In practice, the implementation of diversion result must be carried out at the time. It's asked for time, it will be supervised by the investigator. When the entering the judicial process, in certain cases of the child victim is given the opportunity by the judge to express an opinion of the case in the question. This statement is regulate Article 60, Paragraph 2, Criminal Justice System Law. The last is conclusion. First, diversion is in the best interest of the child victim because the diversion process prioritizes the interest of the victim and aims to achieve peace between the victim and the child. The practice of diversion involves the child victim in with the consent of the child victim. The result of the agreement is an achievement agreed upon by the both parties. Therefore, the best interest in the diversion is not only for the child offender, but for the child victim, like compensation, restitution, like. The second, access to justice for the child victim in the juvenile criminal justice system in Indonesia is seen in the involvement of the child victim in the diversion process and their consent to diversion, agreeing to outcome of diversion, and when the diversion fails, the judicial process, child victim can express their opinion at the trial process. The last is a recommendation for our research, not only for the government, law enforcers, but also the community service, and also local government, P2T, P2A level or UPTD, PPA, under the social bureau in the local government. The first, there should be an advocate for the child victim who is part of the government, as well as a community counselor for the perpetrators, so that the suffering of the child victim and their deeds can be known with certainty. This is to prevent unreasonable requests for compensation. The second recommendation, there should be a legal advisor for the child victim, so that they can be assist child victim in expressing their opinion at all stages to judicial process. This is the last presentation from both me and Rena Julia, and if you have question, clarification, rejection of our result of the research, please don't hesitate to share your expressions, to share your opinion, or to share your question. Again, thank you very much for the committee ICOSEND 2024, the first international conference on social and environment diversity organized by Universitas Semarang, Central Java. Thank you very much.